and welcome, Jeff.
Thank you so much.
So Jeff is here today because he's going to take us through the importance of wills and just some key information that we need in order to make sure that we are prepared and that our estate is in order. So why don't we just get right into it, Jeff? And let's start with, why is a will so important?
So first of all, I mean, it's the last thing anyone wants to think about, like their ultimate demise. And, I apologize in advance if I sort of make light of, a serious topic. It's just to keep it a little bit lighter. But, people don't want to think about it, and they'll put it off and put it off and put it off. But there's a lot of really good reasons why they should. And a lot of them are about family and about protecting their family and making sure that their last wishes are really being followed. So, for instance, without a will, if you have minor children, as soon as they turn 18, they get a big pile of cash. And most 18-year-olds aren't great at managing that. And we've seen it where you have, people in the same family grew up together, maybe like 16, 18 months apart, get a big pile of money. One does like a lot of education, learns how to fly aircraft, does PhDs and, amazing stuff. The other one thinks, cars and boys and tattoos and maybe some drugs are a good way to invest that money. And so being able to put into a trust, and it doesn't cost more, where, the funds can be used for education, they can be used for living expenses, or, and then in terms of bulk sums, maybe at 20 or 25, they get a chunk, and 30, 35, you get to choose. And so it's really important. The other reasons is for things like if something's important to you. So if you want to bequest something to a charity or someone who wouldn't normally get your assets, you're able to do that, whether it's small amounts, whether it's your dog, whether it's, we've seen antique tractors, like any number of things. And everyone has a different part of their life that's important to them. So setting that up and making sure that's in place. With minors, again, of course, we want to make sure that we have guardians in place for them, someone who will look after them if something were to happen to you. And again, it gives you the ability to pick someone who doesn't just say, I want to be able to do this, I want those kids, but someone who really follows your belief system in terms of education, maybe religious or just community involvement, like all of those factors. So it really is important. It's the only way you can control where your assets go and what happens to your kids.
I think as well, there's something to be said for making sure your wishes are known for after you pass. And again, it's not a great topic, but when it comes to dispersing your assets, you want to make sure that there's no back and forth within the family, et cetera, that everybody knows that this is what you wanted to have happen, and therefore it's going to the right place, right?
Yeah, there's two sides to that. So I'll tell people, if anything in here is going to cause controversy, these are your wishes, they have to be followed. You don't necessarily have to let everyone know right away, as long as they know where to find your will and, that part, but it does save people battling things out. So, we've seen people where, one person wants the house and the other person just wants to sell it. If you want to give them the option to be able to buy it first, if you want to give it to one of your kids, like it really, you get to pick everything. And it's kind of a fun choose your own adventure thing where we help people step through the process of a lot of what if, because you don't know what the future holds. So it's like really trying to anticipate as much as we can.
Yeah. And should everyone have a will?
Pretty much. I mean, there's some people that need it more. I think on average, 10 or 15% of Canadians have them in place, which is a really low number. But like anyone who's running their own business. So if you're running your own business, what happens to the shares? Like what's going to happen to that company? We'll talk about some of the other documents later, but we really want to make sure that a business structure is set up so in order for the business to continue for the benefit of your beneficiaries, that it's addressed. Anyone with kids, for sure. Anyone who's leaving a bequest to somebody who has kids or directly to kids, so like to grandchildren, people who have, say, a more risky lifestyle or where they're really concerned about their funds go. One of our reps in marketing just asked, she said, Jeff, like, if I die, because I'm young, everything just goes to my mom, right? I said, oh, is your dad passed? No, but I haven't seen him in 20 years. Well, he's still her parent. So even though her intention is for her mom to get everything, without a will in place, there is no distinguishing between I was going to say good and bad. We'll take the judgment out. A more participating parent and a less participating parent.
Mm-hmm. Yeah. So here's a question then. What if I were to pass without a will?
Yeah, so it's called an intestacy, and we refer to things as probate when there's a will and a letter of administration when there's no will. And essentially, it's the same process, just with different forms. Like the cost is the same, the process is the same, the timeline is the same. With a will, you decide. With an intestacy, the government has set out exactly who gets what, and it starts with the closest in line. So like a spouse, and then kids and parents and siblings, and then cousins, and it keeps going. And people is always concerned, oh, if I don't have a will, the government's going to get it all. Well, no, mostly. If you have no one, like there's no blood lineage that someone comes forward or that exists that you know of, or at all.
Yeah.
Only in those situations your estate would then go into a fund with the province, and it funds universities, colleges. It's for educational institutions. If someone comes in later and says, oh, I just found out that Uncle so-and-so passed, they can then apply to get that out. So that's really the only time the government gets it. It is, though, the will gives the advantage of being able to control the when people get, who gets, and divide it. Going back to the question, who should have them? Anyone who is in a blended family, and we see that so often these days. Again, people will try and either avoid probate or kind of mess up their estate planning by putting two names on title to a home, expecting for the funds to then go to all the kids. And too often we see, if one person passes, it could be years and years later, and maybe it ends up that those kids don't get anything. There's someone new in that person's life. They just choose to give it all to their own kids. So it's the estate planning is where we should be doing that stuff, and not just throwing everyone on title, because there's problems associated with that.
Thank you. And the will is really just the first piece of it. There is an entire package, a will package, that you should be considering. And what's included in a will package?
Yeah, so we always give people a choice. They can pick whichever of the documents. In terms of cost effectiveness, it's better to do them all at once in one package. So it'd be the will, and then an enduring power of attorney, and a personal directive. So a power of attorney allows someone to, we're okay to go on with just explain those a little bit?
Yes, please.
Yeah, all right. So like a power of attorney is where you assign somebody else to manage your financial affairs, your house, your mortgage, your loans, investments, like anything dollar-wise. And an enduring power of attorney is a power of attorney where you give that right to somebody, but it survives if you lose capacity. So, people think Alzheimer's or strokes or things, but it could be anything. We had a client who had his own business. He had an unfortunate accident while traveling, and he had broke his neck, and they had to keep him in a coma. And while he was in a coma, obviously he couldn't make financial decisions for himself, and essentially lost his company because no one can write rent checks, no one could pay employees, no one could, deal with contracts with suppliers and whatnot. Whereas if he had had an enduring power of attorney, that person could have stepped in and said, I've got this document, I'm going to deal with things and make sure everything continues and it's fine. And a few months later, when he comes back, he can step into the process.
So here's a question for you then. It sounds like a pretty significant role to ask someone to take on. What are some things people should consider when they're selecting who's going to represent them in those cases?
Number one is someone you trust. Like obviously that's going to be like the number one thing. Number two would be, depending on the nature of your assets, someone who could manage those assets. So, someone who's just working like a salary job versus someone who owns their own job, someone with significant assets. We had a client who he knew he had medical problems, and he sent his daughter to get her MBA so that she would be able to manage a very significant estate. And I mean, literally, it took her years to deal with it. Now that's once he passed, but had he just lost capacity, again, it's the same situation. So you need someone who, depending on the nature of your assets, if you have some RSPs, you have your house, it's easier. But again, you want to make sure it's someone you trust.
And does it have to be family?
No. No, it can be anyone. In fact, we have a client, and love her to bits. She's 90 something years old, and she has what she referred to as her good son who had passed away, and then her other sons who were less good. So she had her good son's best friend manage her assets, both for incapacity and through the estate, to act as a representative for the estate.
Wonderful, thank you. And what's a personal directive?
So that's whereas an enduring power of attorney deals with your finances, and you get to choose if a person can do that while you have capacity or if it only starts working after. A personal directive deals with your person. So it's going to be, what medical treatment you get or what medical treatment is withdrawn, where you live, like what kind of care facility, what kind of social activities. It's going to be dealing with your humanness, like all your interactions, your bodily interactions with the world, if you can't make those choices for yourself.
Okay. So we can do a whole package if we want. There are choices, I suspect, with you or with any lawyer that we might choose to go to. Yeah. Is it possible for people to do their own wills?
Great question. I love this. My favorite example, the answer is yes. So I think it was World War I, I think it might have been World War II, where the government said, look, we have all these soldiers overseas. They can't go see Canadian lawyers to properly draft their wills. So they allowed for what's called a holographic will. And a holographic will is a will that you have to handwrite it, can't be typed, handwritten, signed at the end. You've got to use the right language, but it allows for you to do that. And my favorite story of this is a farmer. I don't remember if he's in Alberta, Saskatchewan, where he had pinned himself with his tractor. He was like bleeding out. He knew he was going to die because, there's no one around. He's in the middle of a field or wherever he was. And he took his knife and carved his will into the fender of the tractor. And his kids, the beneficiaries, took the fender and filed it at the courthouse as his will. And it was okay because he wrote it, he carved it, and he signed it at the end. And so it was, a valid will. Now, we'd prefer that people use a paper and pencil, but it just goes to show that you really can make things work when you have to.
And again, especially if it's simple, the most important thing, whether you're working with a lawyer with a more complex estate or you simply just want a ring to go to the right person, capturing it in a way that after you leave go that it's going to go to the right person is important.
100%. There's a lot of like pitfalls and traps that people sometimes fall into, and it does take a little balancing, and it's good to know. So, for instance, if you're leaving money to a charity, if you leave X number of dollars versus a percentage, both have their risks, and there's not a right or wrong answer, but people need to make an informed choice.
Could you give us a few quick tips on what we should do to prepare in advance of going to see a lawyer to have our will drawn up or our will package completed?
For us, and I don't know, I think a lot of firms work this way, but I don't know. The first thing we'll do when someone sends us an email is we'll send them like a will information piece, and it has all the things they have to start thinking about. So for a personal directive, say, people will have, like, where do you even start with what kind of treatment I want? And so we guide people through that, and we'll always meet with them person to person or video or phone just to walk them through if they need extra help. But it's a good starting point just for a couple deciding. And sometimes the longest one I had is where a couple spent 4 years. They could not decide on who was going to be guardians to their kids. And I learned a good lesson from them where I finally just said something like, look, this is really important. Like, you've already paid. So it's not like I'm trying to push you to get money out of you guys. If you change your mind like in the next year, 2 years, 3 years, we won't even charge you. Like, it's important to have everything else in place. So it's good to get the steps going so that you're protected.
So on that note, how often should you review and update your will?
It really depends on your personal situation. So if your executor, they're now called personal representatives, but most people know the term executor. If that person passes away or gets too old, or your kids are now old enough that they can manage things, if your asset base has changed significantly, if you started a company and it did well, really major life changes, getting married, getting divorced. Divorce now may invalidate any will you have, and on divorce, most people want to change who gets their stuff. It used to be that if you got married, any will you had was invalid. And that made more sense to me because, you're growing up, I'm going to give everything to my parents, my brother, and then you get married. Well, maybe we should look after, as a social policy, the spouse. So it invalidated the old will, and then the intestacy laws would come in if they didn't have a new one. So just like any kind of major changes, having kids, that's when you want to look at them.
I think too, if I think about the last time I looked at my will, probably, I don't know, maybe 3 or so years ago, I could use a refresher. Like, it wouldn't hurt me to take a look at it and see, what did I say here, just in case something's changed, right? So that can't hurt. I do see we have a question here from someone, but before we get into that, was there anything else that you wanted to note on wills and preparing for getting your estate in order?
No, only that like in terms of law, a will and will package is hands down the best example of an ounce of prevention is worth a pound of cure. It saves so many fights, and will fights are big fights. Like, we once had one family, 3 siblings, a stepmom, with 9 separate actions at the Court of Queen's Bench, all suing each other. When I was a kid, I was probably 10 years old, and there's a sign outside of a Dairy Queen where they had the little, cute little expressions, and it said, "Where there's a will, there's a lawsuit." And I remember this all these years later, and it's true. And the more people say, "Oh, it's not about the money, it's not about the money," the more it's usually about the money. But it really saves so many hassles and troubles, and family members writing their names under a piece of art or something, like, "Oh, I want this," or yeah, they really are a good value for people. And if you don't have one, so let's say you don't have an enduring power of attorney personal directive, instead of being literally maybe a couple $100 to get those done, it's several thousands of dollars, and can take 3 or 4 months making an application to the court to get the equivalent. So like a trusteeship order or guardianship order. And we get that all the time where, someone has a stroke, they can't live in their home anymore, but their spouse can't sell it to buy a new one because that person has no capacity and no power of attorney.
And that's right. They can't sell the house to move somebody in. They can't pay. Somebody has to pay for the expenses, et cetera, that might come up. And if you don't have something in place, it is falling on, hopefully, a family member that can manage that. But if you can't, again, you're saving your loved ones so much time, effort, money, and heartache by arranging in advance to have a will or an estate package of some sort with a power of attorney and a personal directive in place.
Hands down, it's one of the biggest triggers for people coming in is if they go through and deal with an estate where there was no will. They're like, "I don't want my kids to have to deal with that." Like, and then they come in right away to get it done.
Yeah.
Yeah.
Thank you. I have a question here from someone. It says that if I had made a will a while ago, do I have to let the previous lawyer know that I'm updating it elsewhere?
No, it's a nice thing to do. Well, I guess it depends. So it used to be that lawyers used to hold on to the original copies of the will because they want to, like, the estate now has to go to them, and they want the probate work because they want to make more fees on the probate. But you have a indefinite obligation to hold on to that will. So if you don't let them know and they're holding it, then they don't know if you've done a new one or if you haven't, or if you're alive or passed or anything like that. Some firms instead, what they do is they'll give you the will, but they won't give you the affidavit saying that it was witnessed properly. And so then you're still forced to go back to them. And that's a problem because if they've retired and you can't find them, you got all kinds of problems. So if you're trying to find a firm, like, find a firm that's actually going to give you the whole document ready to go, and rely on the fact that they give you a good level of service to make you want to tell the family to go see them again. So but yeah, it's more of an ethical, sort of practical, friendly thing to do, but it's not required. If you feel awkward, fire off an email to their assistant or something.
Now, I always wonder, where do you put the will or the estate package when it's ready, like the will and the personal directive? Where do you keep that so you don't lose it, or that if something were to happen, somebody else can find it? I always think about that as well. So probably want to tell somebody where it's stored, right?
100%. So whoever your executor, personal representative, they should know where those documents are. Again, if something's going to cause fight, so you have 3 kids, you pick one to be executor. You don't want to stir that pot. Like, you don't have to tell them. Just let all the kids know this is where you find my will. If you have a fire safe at home, as long as they know how to get into it, that's fantastic. If you have a safety deposit box, make sure you confirm with the bank that they know who has the ability to enter the safety deposit box to get the will. And if you don't have either, I just tell our clients, put it into a Ziploc bag and tuck it into the bottom of the freezer and just let everyone know where it is. And I mean, really, like, it's rare for people to pass away in a total house fire. If they do, maybe it's smoke inhalation or something, and there offers some protection there. And it's usually water damage, so that Ziploc helps protect it.
Yeah.
Yeah.
Well, Jeff, this has been great. Thank you. I see here, like, you have been with the Boom Group offering our members great solutions for their wills and estate planning from the perspective of personal directives, etc. Excuse me. Right now, you actually have $100 off a will service package, which is great for Boom members. Yay, thank you for that.
Yeah.
You also offer the services of having notary services, which you have half off right now. And then you have a flat rate option as well with a discount of $75 for Boom members. So thank you for all of that. And as I mentioned, you've been with us for many years now. It's been so wonderful working with you. Sorry?
It's been a long time now.
Yeah.
I'm trying to remember how long, but it's been a while.
Helping our Boom members stay on top of things. So thanks for that. We are going to be posting this. So hopefully if there's any other questions, et cetera, that come out of it, we can direct them to you. We thank you so very much for your time today, and I look forward to seeing you again very soon. Okay.
Sounds good. Thank you so much.
Thanks, Jeff.
All right.
Bye
Have a
now.
great day.
Yeah, you too. Bye-bye.